Mr. Gross, did you just have something to say?
No, other than I guess now that I'm already talking, I will ask for a civil assist.
Okay. It is domestic violence allegations, meaning it's subject to Brady and VRA. Named victim is Candace with a K Hernandez. Date of birth 1/12/76. Will activate provisions 1 through 7.
Sadly, I can't do anything going backwards. Okay. We had an off-the-record conversation there briefly. We'll go back on the record here in the matter. Just want to make sure and remind everybody that we are set here today for a sentencing hearing regarding the jury verdict of last week. I do just try to let people know what the court's expectations are going forward, because I know that this can be a highly emotional issue. I'm just going to request and make sure that everyone utilizes appropriate language as we are in a courtroom. Because this is a sentencing hearing, the issue to be decided is what is an appropriate sentence for me to impose. And so I would ask that if you would focus your comments towards me, as I am the only person that can do anything going forward on this case. Sadly, I can't do anything going backwards or change anything that's happened in the past, but I can focus on what's going to go on next here after with the sentencing. So because the decision is mine today, please keep your comments focused towards me, not about anybody else in the courtroom, the lawyers, witnesses, the jury. I can't retry this case. We've already reached this portion of the case. I will say sentencing is some of the hardest parts of this job. And so I am truly interested in what you have to share with me about what decision I need to make today. And so there is no other cases here this afternoon. We have blocked this afternoon off to listen to everybody's perspective and point of view on what actions I should take in the future. And so that I can focus solely on what you have, your thoughts about sentencing to share with me. How would you like to start?
We would defer to the court on which side you'd like to hear from first. We do have one member of the victim's family that wishes to address the court.
For defense, do you wish to start first, or do you want to wait or not have any further argument or statement about sentencing?
I defer to the court, however you want to do it.
All right. I'm going to ask for if the people who are ready to start and whoever they wish to call.
Your Honor, the people are first going to ask the court to hear from the named victim, Valerie Garcia, her sister, Alexis. State your name.
My name is Alexis Garcia, Alexis, last name Garcia.
Good morning. Good afternoon, Miss Alexis. What would you like me to do?
Oh, that's okay. My name is Alexis Garcia, and I'm the sister of Valerian Michelle Garcia. There are no words that can truly express the pain of losing my sister. She wasn't just my sister, she was my family, my friend, and someone I thought that I would have the rest of my life. Instead, her life was taken in an act of unimaginable violence when the person who claimed to love her chose to shoot and kill her. Every day since her murder, it has been filled with grief that truly never goes away. I've had to accept that I will never hear her laugh again, celebrate another birthday with her, call her when I need advice, or make any new memories together. There's an emptiness in my life that can never be filled. What makes this even more heartbreaking is knowing that her life ended because of somebody she trusted. She deserved to grow old, to chase her dreams, and to live and fill her life. Those choices were stolen from her in a matter of moments. This tragedy has affected every part of our family. Holidays, birthdays, family gatherings are no longer the same. There's always an empty seat that reminds us of who is missing. The pain doesn't end after the funeral, it continues every single day. I want the court to remember that my sister was not just another case number or a name in the courtroom. She was a beautiful human being who was deeply loved. She mattered, her life had value, and she should still be here today. Nothing this court does can bring her back. No sentence can erase the trauma or heartbreak or lifelong pain that our family has to endure. But I hope that the sentence reflects the value of the life that was taken and the devastating consequences of the defendant's actions. To my sister, I miss you every day. I will continue to honor your memory, speak your name, and carry you with me for the rest of my life. You deserved a much better ending than the one that was forced upon you. I love you and always will. Thank you, Your Honor, for allowing me to share the impact of the loss on the life of my sister, Valerie.
Thank you, Your Honor. And as the court can see up in the front of the courtroom, in front of the prosecution table, those are pictures of Valerie Garcia, provided by her family. They just wanted the court to be able to see her and not in the way that she was presented during the trial. Your Honor, at this time, we are asking the court to first find that this was done as an act of domestic violence. That is a finding to be made for by the court, not by the jury. We're also asking the court to impose restitution in the amount of $15,280. We will be following up with a written motion and order, $15,000 for funeral expenses, $280 for therapy for the family members. Your Honor, there is only one option available to the court under Colorado law. And that sentence was created by the legislature to codify the seriousness of a conviction of murder in the first degree. The mandated sentence of life in prison without the possibility of parole was created for cases just like this, for cases where a person was murdered intentionally and after deliberation for no reason at all. I won't belabor the facts of the case because Your Honor was present for the duration of the trial. But I want to highlight a few things. It was after 17 minutes. 17 minutes after Jesse Gladney went to collect Valerie Garcia from that Super 8 motel in Westminster, Colorado, that he murdered her. While in the car, after threatening to shoot her repeatedly, it took 9 additional steps for Jesse Gladney to make the decision to intentionally kill Valerie. And for what? Because he didn't want her to speak anymore. We know Valerie was terrified of Jesse. On the surveillance footage of the hotel parking lot, Valerie is seen reluctantly following Jesse to the car after he repeatedly yells at her. Due to that reluctance, Jesse then assaults her, slamming her head into the car before shoving her into the back seat. Valerie did not want to go wherever Jesse was going. She wanted to go home, something that Sonia recognized due to the behavior of the defendant and was going to take her home after dropping Jesse off. But Valerie never made it home. She never made it home to her kids and to her family. The wound path suggests that Valerie might have been trying to turn away from Jesse, but she had nowhere to go. She was backed up against a door and a seat. And it only took one shot straight through the chest to kill Valerie. When you look at Mr. Gladney's criminal history, riddled with aggravated offenses and multiple domestic violence convictions, including 5 felony convictions, 3 prior domestic violence convictions with 2 other women, 1 being attempted stalking, 1 being assault in the 3rd degree, another being assault in the attempted assault in the third degree. And now a third domestic violence victim is on his record. When you look at criminal history such as this, in conjunction with the aggravated facts of this case, this senseless and unexplainable death serves as a devastating reminder to the court and the public regarding the extreme risk and danger of crimes of domestic violence that poses to victims and the community, especially victims that are stuck in this cycle. This sentence that the court will impose will never bring back Val, something her family and her children will have to live with every day for the rest of their lives. But it is cases such as this, one that the people hope remain the memories of this court and the public and our state legislators to emphasize the gravity and increasing lethality of cases where domestic violence exists. That although rehabilitation and treatment are important, punishment for these cases are equally as important so they don't get to this level of murder in the first degree, a woman taken from her family far too young. This is the reason why a sentence such as life in prison without the possibility of parole is the only justified sentence in cases such as this. And we're asking the court follows the statute and sentence Jesse Gladney to life in prison without the possibility of parole. Thank you.
Anything further from the people?
Nothing further, Your Honor. Thank you.
Okay. For defense?
I believe Mr. Gladney would like to speak to the court. I will advise the court that, given the nature of the sentence and that the court has really no discretion but to give life without parole, I have no argument.
Does any of his family wish to speak at all, or just Mr. Gladney?
I do not believe that, I guess his mother does wish to speak.
Okay.
Can he speak from the table?
Yes, he can, if you wanted to step forward to the, if the mother would want to step forward first.
Hello, Your Honor. I just want to know if I could speak to you, but say something to the Garcia family.
It wouldn't be appropriate at this point in time, given where we're at. The sentencing hearing is solely up to me in the sentence.
Understand that.
So if there's something that you wish to me consider regarding the sentence, you're free to share that.
Okay, and this is what I know. There is nothing for you to consider at this point because this is a life sentence regardless. So I understand that. And I understand that you are bound by this decision by law. I understand that. But I do want to say that my son is not what people have made him out to be. And the people that really know him know that. Okay? He's a loving father. And he loved Valerie Garcia. I used to talk to her all the time on the phone. Okay? I knew her personally. She loved him. I used to tell her, if you guys fight all the time and argue all the time, why don't you leave him? Because I don't want to. I love him. I see that there is something in him. There's good in him. I advised her to leave him many times, but she wouldn't. And that's things that nobody knows about because I was supposed to testify, and at the last minute, I didn't. There's so many things that I know between him and Valerie because she talked to me on a day-to-day basis. Every other day, we talked a lot. I am the third person in their relationship. I have firsthand knowledge of that day. I was on the phone with them the entire day and evening. But I wasn't allowed to speak about what I know. So the things that were said here today, I know for a fact were false. And I know that makes no bearing on your decision because it's already made. But I do want to say something to my son, if that's allowed.
No, not at this point in time, but you will be able to privately at other points in time during visitation or things like that.
All right, Your Honor, I understand that you get to make this decision because you're the judge, but I also know that my son only has one judge, and that's Jesus Christ. Okay?
Mhm. Okay. Mr. Gladney?
Yeah, I just want to say something to my mom, my family. I just want to tell my mom that I love her so much for having my back through everything. And thank you for teaching me everything I know in life. And she the realest person I ever met in life. And I love you for that. And to my wife, I love you for supporting me and having my back through all this and not judging me and seeing it for what it is. And my family that's watching, I want to say thank you for supporting me and loving me and knowing the real deal. And to my papa, my dandina that's behind me, thank you for always loving me and supporting me and never turning your back on me as well. And only person I hope the Garcias feel peace and they get closure now, you know. But I have my thoughts and feelings about that, but I'm gonna keep it to myself. And the situation from last week, I know those are just empty threats because I just know those are just empty threats. And yeah, that's all I want to say right now. And that's all. Thank you.
Yes.
I was waiting for defense. I just had one further thing, record to make, Your Honor.
All right.
And that is that, just for the record, the people never made an offer in this case, and we were not going to ever make an offer in this case.
Okay.
That's all. Thank you.
Okay. Thank you. As I said, when I first started, this is usually the hardest part. And I do know, and as everybody here understands, what the sentence is in when the jury came back with their verdicts. And how that we will be moving forward given the jury's verdict. I appreciate everyone's efforts to be part of this case, the professionalism of both the attorneys in this matter, and how the families appeared and did try to maintain composure in a very challenging and difficult situation. And it will be the court's expectation that that continues, and that that there be a separation at the end of today's hearing. I appreciate the defendant's statements regarding thanking the people who support and love him. The hardest part is that Valerie doesn't get to do that today. And Valerie no longer does get to have the support and love of her family and do the reverse and give that support and love to her family. And that's the true challenge, the true sadness and the true tragedy of this whole case, that we didn't have to end up being here as where nobody wanted to be, and that we lost what I've heard about, and I can see a true light in our community and someone who was taken from her family way too soon and unfairly. And I know I can't ever get her back for you. And that's the hardest part of coming with this part of the case. I also understand, and I do appreciate that Mr. Gladney did indicate that he hopes the family does have peace and closure. I never say that because I know it's much like I never try to say the words moving on or healing, because I know no one truly moves on or truly heals from this. All we do when faced with tragedy like this is we just get stronger with carrying the pain, carrying the burden. Our heart gets heavier and better able to deal with the insurmountable grief that you all feel right now. And that's all we can do. And so the court does wish the family, every member of the family, that strength to go forward and go on, even carrying this tremendous loss, an unfair loss. At this time, the court will find that the jury's verdict of murder in the first degree was an act of domestic violence. Will authorize the people to file a motion regarding restitution, and the court will take a look and review that, and will set any deadlines or timelines required by statute. And then finally, the court will sentence Jesse Aaron Gladney to life in prison without the possibility of parole. Anything further? All right. It's
I would ask that the minimus read 784 days credit for time served.
okay. Any objection from the people?
No, Your Honor.
Okay. I'm sorry, the number that you said?
784 days.
The minimus will reflect that the defendant did spend 784 days in custody prior to trial. However, given the length of the sentence as life without possibility of parole, it has a minor bearing on the ultimate imposition.
In the future, things were to change. That's why.
That's true. All right. Anything further from the people?
Nothing from the people, Your Honor. Thank you.
Okay. Anything further from defense?
No, Your Honor.
All right. At this point in time, I'm going to just ask if the defense can step out, and we'll have this done in a staggered manner. All right?
We'd like to watch him walk through the door if that's okay with you.
All right.
Thank you, Nancy.
Jesse.
Ma'am, please.
It looks like I have a Rachel Carr present, so the court will call 23 CR 1726. Miss Rachel Carr appearing out of custody via WebEx. Ms. Carr, good afternoon, or good morning, I should say.
Good morning.
Ma'am, it looks like you are here on a complaint to revoke your unsupervised probation. Ma'am, what is your intention in terms of a lawyer? Are you going to be applying for the services of the Public Defender's Office, or hiring a private attorney, or representing yourself?
Your legal counsel.
Representing myself.
Okay, do you have any legal training or experience?
I do not.
Okay, do you see how that could potentially impact you negatively, not having the ability to have that training and experience navigate you through this case?
Yes, I have my husband helping me.
Okay, does he have any legal experience?
Yes, lots.
Yes.
Okay. All right, then we'll set this over for an Arguello advisement in Division 11 with Judge
She shouldn't be
Lakefield.
going anywhere. She should be, her probation should be getting taken off because she's, this is a violation of due process. There should be nothing. She should have been taken off.
Sir, you're not an attorney and you're not a party to this case, so please refrain from speaking at this time. We will
I am her
again.
counsel and power of attorney.
Okay. Or do you have an attorney registration number?
Is there a license? Do you have a license to practice law?
I do. Do you?
You do? What is your license number for the state of Colorado?
Sir, I don't have to give that to you right now. I do. My question was for you.
I have power of attorney over her.
Sir, I'm not engaging in this with you. If you want to represent yourself as an attorney and you're not licensed, that is potentially a crime. And
No,
so,
it's not. I'm not a U.S. citizen.
okay.
Therefore, it doesn't apply to me.
All right. And so we'll set this case over for an Arguello advisement in Division 11 with Judge Lacefield. August 18th at 10.
It's a violation of due process.
All right, ma'am, do you have any questions for me about your next court date?
No, I don't.
All right, ma'am. And ma'am, again, you are on, it looks like the summons, and so I'll continue your summons until that date and time. Thank you.
It's a violation of my due process, though. I thought that I was supposed to get off probation last month.
Okay, and the prosecution's office filed a motion to revoke that.
Why?
Again, you can speak to that. The allegations is that you were charged with a new law violation, and
But
that is
that's an allegation. That's not, I haven't been convicted, right?
And you can request a revocation hearing with Judge Lacefield. He'll be the judicial officer who will handle this case and that you can raise all your concerns with going forward, okay? Thank you. Have a good day.
I'm going to recall case. '25 CR 269 at People versus Allen. Can I have appearances, please?
Katie Wells for the people.
Mr. Allen, state your name into the microphone, please.
I'm here.
No, state your name. I'm here doesn't work.
I'm Alan.
Full name.
You only said her last name.
State your full name. Mr. Allen?
You know who I am?
I've directed you to state your full name. This proceeding is being audio recorded and we need to get a good record. That includes an appearance.
I'm the indigenous Isaac Allen.
Right. Let the record reflect there's a current active bench warrant for Mr. Allen for his failure to appear at 10:30 this morning. Given his reappearance and your availability, Ms. Wells, how would you like me to proceed?
I'm asking that the court find a failure to appear and remand Mr. Allen. I understand there are issues to litigate, but Mr. Allen had notice and the opportunity to show up on time. He failed to do so, and I'm asking that the court remand him as a result.
I got there off the airport at 9 o'clock. My airplane landed this morning, so I told you guys I was going out of town.
Yeah, no, Mr. Allen, I will tell you what you were told on July 16th. That we were resetting this for 10:30 today. You had responded that you might be out of town. And I told you that you better prioritize because I was coming in even though I had a conflict on my schedule. And you have now kept everyone waiting 45 minutes. So you don't get to choose what time you appear in court.
I do what I could to get here as fast as I could.
You did not do what you could to get here.
If my
Tell me why you needed to be out of town.
Because it was my daughter's birthday. It was her 21st birthday. That's why.
Yeah, that's not reason.
Yes, that's reason enough for me.
Yeah.
You only have one daughter. What would you do? If you don't have one daughter, that's where she wants to go.
I would prioritize my penal interests and get to court.
Well,
So,
I'm here.
I'm considering remanding you into custody because of your obvious and intentional disregard of my court orders.
No, I respect it very much. I tried to get her as fast as I could.
No, you were ordered to be here at 10:30 and you didn't, and you chose to go out of town and get on a plane
Let's
and
go-
arrive at 9:00, which I still don't understand how you couldn't get here by 10:30 from the airport.
With your baggage luggage? I mean, I had my son come pick me up. I mean,
Mr. Allen, do you understand that I'm not interested in why you chose your personal life over court orders?
personal life is over court. My life is, this is nonsense. This right here is nonsense, as what I see it. I
All
mean,
right,
right now,
take a seat.
District
Take a seat.
attorney can't even prove the case.
Take a seat.
Let's go over the matters at hand. We're wasting time now, right?
Yeah, you're wasting everyone's time. Give me a moment. Okay, we're still on the record in 25 CR 269. I've taken the prosecution's request into consideration and under advisement. And given the fact that we have some substantive issues to address today, if I remand the defendant, we're going to have to address those Monday morning, thereby further wasting time of other individuals, in addition to the time that's been wasted at the behest of Mr. Allen today of everyone else. So I reluctantly am going to quash the warrant. The PR bond is reinstated. And we are going to trial Monday morning. Mr. Allen, you need to hear me and hear me clear. Well, first of all, I'm going to attach a monetary amount to the PR bond. I'm going to increase.
I'm on a PR bond in this case.
Oh, you're on a 2,000 cash surety. Okay, I'll reinstate that cash surety bond that was forfeited today. And I'm going to make it very clear, you were ordered to be here at 9:00 on Monday. That does not mean 9:01 or 9:02 or 9:05 or any time thereafter. If you're not here at 9:00, a bench warrant will issue. The jury will be sent home and that bench warrant will go active immediately. Do you understand that?
I hear you.
And if you fail to appear Monday, that bench warrant will go active with a $4,000 cash only bond attached to it. So with that, we need to address, I just want to, for the record, there's several motions that have been filed. I'm going to talk about the notice, which includes the motion to suppress, filed on July 22nd, 2026. There's two, as far as I can see, two motions and requests, including in there the unlawful stop and search. That's denied for the same reasons all of the other motions have been denied. There's a re-request for discovery. Ms. Wells, I'm not sure if this is the same request as prior discovery, but can you address those?
Is this as to the motions filed on July 28th, Your Honor?
22nd.
I did confirm, though, with our support staff that any discovery has been sent, any and all discovery has been sent to Mr. Allen. I can make a further record in just one moment.
I have a blank CD to prove that she did not. So I came in here and picked up the CD that she said was supposed to be the.
Mr. Allen, let me tell you how I want this to work. When I call on you, that's when I want you to tell me your position. But right now I'm listening to Ms. Wells and she's reviewing her information so she can give me more information. Please do not interrupt.
Okay, so Your Honor, it sounds like when the CBI report was received, that was the new evidence that we mailed Mr. Allen notice of and that we wanted, or that he, I think, intended to come pick up. It sounds like the new evidence was only that report and nothing in Axon or evidence.com needed to be updated. So that might be why the disk was blank. In any event, I can print a copy and hand it to Mr. Allen today. Or, I mean, if that's the remedy the court would prefer, I can do that. That's the quickest way, I think, to get him whatever he's alleging he's missing.
Okay, so that would be the report itself.
Yes.
Do you have the report itself, Mr. Allen?
No.
Okay.
I don't have anything that she sent me, and it's all circumstantial evidence now anyways.
All I asked was yes or no.
No, I don't have
Okay.
anything that she's
Please-
supposed to send in the
Please
email.
have that printed, Ms. Wells, and you can provide it to Mr. Allen. But actually, I need you to turn to the notice of July 22nd. It's filed notice, but it's actually a motion. And there's requests for discovery and inspection. There is, with respect to, well, first of all, let me handle some of these. Some of this is for body-worn camera footage on the date. This is regarding the date of the incident at 6600 West 120th Avenue?
Yes, Your Honor.
Okay, and that's been provided?
Yes, Your Honor.
Okay. I don't know what a magical CD is. Mr. Allen, do you want to respond?
Yeah, she held it up in the court during motions hearings that she had a new CD that had all this information on it from the officer testifying that he had all the CAD report and all that other shit that she said.
Okay, watch your language, or you're going to be held in contempt. Do you understand that? That disrespects the dignity of this court. Watch your language.
Freedom of speech.
Nope.
No person can be deprived of rights.
Mr. Allen, are you begging to be held in contempt of court?
I'm just saying.
I suggest that you use respectful language. All right, so I'm going to accept the district attorney's statement that all body-worn camera footage and dash cam footage, if available, has been provided. The dispatch audio and CAD logs, this relates to the arrest itself. I don't see how that is relevant to the issues left for trial. This seems more relevant to the suppression issues which have been decided. But Ms. Wells?
Those have also been discovered, Your Honor.
Okay, those have been discovered. The prior altercation, the search and basis of scope, that again, it seems irrelevant in terms of the issues at trial, because these were reasons for the stop and the search. Ms. Wells, do you have any record to make on that?
I don't, Your Honor.
Okay. The photographs requested are for plate, steering column, interior vehicle condition. Again, I don't understand how that's relevant to, I don't understand how that's relevant to the issues remaining at trial. That appears to me to go to the suppression issues. How is it relevant to the elements the prosecution has to prove in this case? Mr. Allen.
Well, because you had an officer sit up here and testify that this is what really happened, which that's not exactly what happened. If that was the case, why do you wait 1.7 miles to pull me over? I mean, what he's trying to say and what he said, and that I matched some previous guy, that's all circumstantial. That's going off a hunch.
All right, so I'm going to find, based on the statements of Mr. Allen, this relates more to the suppression issue, which already has been decided, and I'm not going to order any disclosure.
Yeah, this is
The drug testing documentation will address in the other motion. Well, no, we won't. We'll address it here.
Well, there's other
The
news.
field test documentation, the DA has already indicated that they don't intend to admit it. You filed a motion to suppress that. I'm granting that. That means no party can introduce any evidence of any field testing. That was based on your motion.
There's no field testing and there's no drugs whatsoever. I shouldn't have been arrested in the first place.
Mr. Allen?
Without before it again.
Mr. Allen, it's not your turn to speak.
Mm.
The lab test documentation, that's what's already been provided.
No, it
and
has
Wells
not.
is going to give you another copy today.
There's not.
So that takes care of that motion.
She mailed me a letter.
Then we have the motion to
it's the-
suppress filed on July 16th. I already denied the first portion, the suppression issue. The field test, we've already spoken about, and that is inadmissible by any party, including you,
No,
Mr.
I
Allen.
want that to be missed. I want that to be able to be missed because if that's.
You moved to suppress it
Then if there's-
on the grounds that it wasn't admissible.
If you can't, then the drug.
Stop
then the drug-
interrupting me.
The drug shouldn't be done either. The drug shouldn't be done.
I'll be back.
That ain't admitted, the drug should not be admitted. It's not due process of law.
You in direct contempt of this court. And there will be a punitive sanction, which will be remand into the custody of the Broomfield Police. So this is your warning. Please do not speak over me. Please do not speak over the district attorney. Do not disobey my orders when I ask you to do anything in this courtroom. Failure to do so is going to end up in a direct citation for direct contempt. So let me proceed. We've already addressed the field tests. It was your motion, Mr. Allen, to exclude any field testing in this matter. The DA agreed that field testing is not admissible at trial in this case under the rules and laws of Colorado. So the order of this court is that field tests and any reference to field tests is not admissible by any party at trial. With respect to the chain of custody issue, the district attorney provided documents reflecting that chain of custody. Your arguments, Mr. Allen, appear to me to go to the reliability of that chain of custody, which goes to the weight of the evidence, not its admissibility. I will give you the opportunity to make a brief statement on the chain of custody issue. What would you like to say?
The chain of custody, I've never, any evidence that's admitted 30 days before, prior to any trial is all inadmissible in the U.S. Colorado state statutes or your codes. The blank CD and what should have been on it is not even on it at all. She has a list of what was supposed to be on here. There's nothing on it whatsoever.
Are you talking about the CD? I don't think
This is the CD that they've done.
Mr. Allen?
You asked me to speak and I'm trying to explain it to you.
I know. But when I start speaking, you need to listen because we're going off on a tangent and I want to redirect you. The chain of custody evidence was in paper form attached to the pleading.
No.
It was not on a CD, correct, Ms. Wells?
Nope.
It was, I believe it was an exhibit to this motion because I reviewed it and looked at it.
Yes, and those have both been discovered to Mr.
Okay.
Allen.
No,
There's nothing that has to do with a CD with respect to that. So with respect to the chain of custody, you've made your record in the fact that you believe it wasn't on the CD. I've told you it didn't need to be on a CD because it was part of a paper pleading and given to you.
She did not
Do
send,
you have anything else to say?
yes, she did not send it to me. She sent me a letter saying I could pick up the evidence and on a CD. That's what she told me to say in the letter. I have the letter still today for that's what she said. She didn't send me nothing in the mail like she said she stated in court on motions hearing. She said she sent me the lab report. I have not seen a lab report whatsoever.
Hold
Not
on,
one.
we're not talking about the lab report. We're talking about the chain of custody
chain of custody-
documentation. Now you're done, Ms. Wells. Do you have excuse me?
I said, I'm talking to myself.
No, you're talking out loud into a microphone.
Well,
Ms. Wells, when did you provide the chain of custody information and how?
It was discovered with bait numbers 120 through 125 and 126.
And
And I'm confirming how those were provided.
and when?
Just one moment, please, Your Honor.
And in any event, I'm submitting the evidence submitted receipt. I'm printing it out for Mr. Allen right now.
that's,
In any event, I'm going to deny the motion to suppress the talks reports due to any chain of custody issues. That's denied. The motion to suppress on July 28th was already denied. The motion to preserve the body-worn camera videos was also denied. And the motion to dismiss for speedy trial violations was also denied, and written orders were issued in that regard. That's it for motions. So now we need to get to the pretrial stage of this matter.
this is
People announcing ready to proceed Monday.
Yes, Your Honor.
Is defendant announcing ready to proceed?
no, I'm not going to proceed because this is all, I'm going to have to go above you guys. These go to the federal, this is BS. This is totally wrong. What you just stated is completely wrong.
Sir,
The day you got, the day I got.
Mr. Allen, I'm asking you to stop talking.
Mm,
And this is not the day to argue the merits of the case. That's what the trial is for on Monday.
no,
So,
that's not gonna happen.
well, then you need to give a waiver of speedy.
I'm not gonna do that. You already threatened, you already violated my rights on that. You've already violated my rights on that
No,
speedy
I
trial.
didn't.
Yes, you did by
Okay.
threatening me to do it.
We are going forward on Monday.
Okay, that's fine, that's
for a
fine.
jury
Just so no one
trial.
else will be-
Stop talking.
I wasn't done talking yet. You can talk over me, but I can't talk over me.
Yes, I can.
Okay, so that's disrespectful. Either way.
All right. I'm going to find that Mr. Allen has been consistently combative in court today. He has refused to follow the directions of the court. He was disdainful of the court when he was 45 minutes late. He continues to talk over the court. He has made statements after I warned him and gave him essentially an opportunity to change his behaviors. The behavior is not only disrespectful to the court, it's disrespectful to everyone in this courtroom, and it's disrespectful to the judicial system. I don't believe that I think the conduct is offensive to the authority and the dignity of the court. I'm concerned about Mr. Allen's ability to refrain from continuing to engage in such conduct. I'm inclined to impose sanctions here, as I've already indicated, which is a remand into jail. You have the right to make a statement in mitigation before I issue that order. Would you like to make a statement?
Your Honor, I'm not trying to disrespect the court, but what I'm saying is, you asked her a question, she didn't come up with the
Hold
answer
on.
of what she said, what time, when she got this paperwork to me. This is the first time I've ever seen this paperwork.
But sir,
But I'm
the
just saying-
problem is
I'm not
that
gonna-
you were not following my directions. Would you like to make a statement in mitigation such as an apology?
Yeah, I apologize to the court, but you gotta
Are you
understand.
going to?
I just did.
Was it really?
Yes.
All right, you get one more shot. And then you're getting remanded. Do you understand that? So we are going to trial Monday. You have not given a voluntary waiver of speedy. You have been provided information with enough time to proceed to trial. So you need to be here at 9 o'clock. 1 minute late and a bench warrant issues, given your conduct today. In fact, that you were very, you didn't seem to care to follow the timeline that was imposed. In any event, let's talk about trial. So, with respect to trial, and I will tell you, Mr. Allen, if this behavior occurs in front of the jury, again, you will get a warning. And if you can't follow that warning, you will be removed from the courtroom if you disrupt the proceedings. We'll set up a place for you so you can appear by WebEx. But if you are disrupting the dignity of the jury trial and this court, you will be removed from the courtroom during the trial. So, with respect to pre-trial, how much time for voir dire are you requesting?
I would ask for 25 minutes, Your Honor.
Okay. Would you like 25 minutes to ask questions of the jurors, Mr. Allen? Yes or no?
I still have a problem with the issue before. I mean, you granted something that doesn't even make any sense. The time and date on it isn't the same. I got it.
Mr. Allen,
This is ludicrous. This is ludicrous right now.
I
Trying to keep my-
agree.
It's ludicrous. I mean, there's
I agree.
25 minutes. Sure, we'll do.
Are you going to stop
25
talking?
minutes is fine.
All right.
You just
I'm
asked
going
me
to find
25
that
minutes.
the defendant is in contempt
Just asked me
of
25
court.
minutes. 25 minutes is fine, I said.
I'm going to order the defendant remanded into the custody of the Broomfield Police. And
This is not due process of law. Guys, just calm down. Let me get my stuff to my son.
We will set the return date on the contempt at 9 a.m. Monday morning, at which point you'll be advised.
Your Honor, can I say one thing, Your Honor?
Nope. I gave you,
No,
I gave you at least 2 opportunities.
Your time to speak is over. My stuff.
All right. We'll see you Monday morning at 9 o'clock.
Thank you, Your Honor.
Okay, Mr. Burns, how you doing?
Doing fine, a lot better, and
Feeling better?
yeah, I was very sick. You know, I went to the VA. They had parasites in my stomach from eating pork. So it was horrible. I was vomiting like continually.
Oh.
So I'm okay now, you know, I've been cleaned up. They gave me barium and everything else to kill the parasites.
Okay.
So how are you doing, ma'am?
I'm okay. I stayed your warrant till today because Mr. Abermite said you were sick.
Yeah.
And so, this is 25T4716. We were trying to get you into the competency diversion program.
Right.
Ms. Zenzen, do you have an update for that?
Your Honor, that referral request is still pending. I did send that 2 days ago to the senior or chief DBA Redfield who runs that program. She reviewed, or through our office's side, and then she has to review that with our ADA, even though I'm just waiting for cancer. As soon as I get that, I can file a notice to the court and Mr. Allen can file it, and then perhaps if the court is amenable, we could vacate our on Thursday.
Okay. So, Mr. Burns, we're still trying to get you into that program because I think that would be a really good option for you. So I'm going to give you another pretrial conference date here.
Okay.
If you do get into that program, we will give you a date in that new division.
Okay. And I signed up for drug and alcohol testing, and I'm waiting for them to call me when I should go in
Okay,
for that. So
okay,
I'm trying to do everything I can for you, ma'am.
okay. And you still have your breathalyzer?
Oh, yeah. And it's been zeroed.
Good.
I stopped all that crap, and I only did it that time the night before that my wife and I would have dinner.
Right.
And then go to Culver's.
Okay,
And I was pretty jacked up after 12 hours of drinking.
Yeah.
I was doing it just to commit suicide, I think.
yeah,
So, you know, I hurt.
right. And that's why I'm trying to get you into this competency program because I think that would work, but we have to get it approved by the DA.
Yeah.
I'm going to have you back August 25th at 9:30.
Okay.
So the 25th at 9:30.
Yeah, ma'am, I'd like to get this all straightened out. I'm with Atlantic Records now, and I have hit number 3 here in the United States and number 1 in Europe. And I'm supposed to go to Germany
Oh, okay.
for, you know, on tours.
So we have to get this figured out.
Yes, ma'am. Thank you so much.
Okay, then we will see you back to, okay?
Yes, ma'am.
Okay, thank you.
You have a great weekend.
You too.
Oh, yeah.
Thank you.
My house is being emptied out, my 5 bedrooms. I got everything to be ready to move to a new address.
Okay,
So,
okay, good.
okay.
You're
God
moving
bless
on.
you.
Okay, thank you, Mr. Burns. We'll see you.
Mr. Burns,
Mhm.
do you want me to come outside with you?
Yeah. Okay, I'm gonna call Cindy Robinson, 26M2729.
She's got comments out of the FAC. And this is a third bill to appear. We'll do a $400 PR bond. And what's your name, sir? Okay. Did you say Christopher Cosby? 26T2987 is set for a pretrial. And then 24T6447 is in revocation. What's happening?
Judge, at Mr. Cosby's last court date, the DA extended an offer. I have not had an opportunity to speak with them about that offer. I'm not aware of what it is. He was told to apply for public defender representation. He's obviously since done so. He's been approved. So at this point, we'd be asking for a set over so that I can talk to him both about the revocation matter and the new case. I do not have any discovery in the new case, so I'm obviously not able to.
We're just appointed, it looks like, on the 28th.
That's correct, Judge.
Can you put the offer on the record again, Ms. Senzen?
Yes, Your Honor, the offer in 26T2987 is to plead guilty to DUI second offense with standard conditions, as well as 20 days jail and 72 hours of public service. Restitution reserved and the VAC was 0.226.
Okay.
And I apologize, I do believe there will be restitution beyond, or there is potential for restitution beyond the blood test given the crash, but we're still looking for this.
And can I get a report from probation for 24T6447?
Yes, Your Honor. So, he is, I do not believe he is currently in treatment anymore at Gateway to Success. He had 38 of 52 hours completed. He did have 27 enhanced treatment hours, so I'm not quite sure if that counts towards it. I have to look a little further into it, because if it does, then he'd be completed. I'm not positive though. Community service hours, he has 120 of them that he's supposed to do. As far as I understand it, he does not have any completed. Victim impact panel, he has not done that. He previously, when he couldn't afford to do a UA, he'd come into the office and he'd do a breath test. He stopped doing that a while ago. He stopped doing that right around the time he got this other DUI. He has court costs and he owes TI $350. Probation is respectfully recommending revoking and closing with jail on technicals. Probation's concerned with community safety. He's obviously still drinking and driving. And so it's for those reasons that we are asking to revoke and close with jail.
Okay. Well, that's not good. I'm inclined to take him into custody on the complaint and report based on that.
Well, Judge, probation is bringing up a lot of things that are not in their complaint and report that was filed on June 30th of this year. Mr. Cosby has a due process right to notice of the allegations against him and an opportunity to be heard on the matter. If it's not in their report, obviously counsel cannot meaningfully respond to the new allegations that are being put on the record today.
That's why I would take him into custody and set it for a hearing, and then have his due process hearing and an amended complaint, I assume. But I have enough in this complaint to revoke his probation and set him for a hearing.
And Judge,
Just based on the missed UAs, the lack of fees, and the new allegations in the new case.
at Mr. Cosby's last court date, the court ordered him to get on random sobriety monitoring with Colorado Health Services.
You don't have any of that in the file.
He's since enrolled, and I have proof of enrollment here.
So when did he enroll?
Just this past week. And he was quite sick from what he told me shortly after having his last court date. Mr. Cosby's.
I came down with the flu and I had a fever, was throwing up, everything. So I was a little late on getting everything done. But
I'm just asking when he enrolled, because he was in court on July 23rd. And if it was yesterday, then that's not helping the matter.
it was a couple of days ago.
I don't have a date of enrollment. but-
because they also wanted me to bring in the referral and I had left that at my apartment. So I had to come back with that referral.
Also, if the court were to take Mr. Cosby into custody today, he would lose his job where he works for a company called Cut Above doing tree removal services. He's been doing so for several months. He works nearly every day, from my understanding. And obviously would be severely prejudiced by that.
Well, and that's good. And I want you to keep working, Mr. Cosby, but you still have a lot of obligations to probation that aren't completed.
And now that Mr. Cosby has the benefit of counsel, I can advise him on that.
Should advise him he's very close to going to jail.
Yes, Judge.
And at the next court date, if I don't get a better report from probation, I will be taking him into custody. And then we'll be setting a hearing on the technical violations that are in the complaint report. Is that clear?
Yes, Judge.
August 25th at 9:30 for pretrial conference on 26T 29. Actually, I'm going to set him on the revocation hearing docket. So we can be ready for a hearing. I'm not going to push this out anymore. So I'm going to set him on August 25th at 10 o'clock for a hearing on the complaint report in 24T 6447. And then, Mr. Crosby, you need to talk to your attorney about the new offer in your new DUI. I also need to see sobriety monitoring immediately, or I'm going to issue a warrant.
Okay.
So the biggest thing right now is for you to stay sober. There's no alcohol, recreational marijuana, or illicit drug use. And you need to be reporting to probation. Does he need to set up
an appointment? Yes, ma'am.
You want to do that in the hallway?
Yes, I can.
Okay.
Do that.
So you need to set up an appointment, and between now and the 25th, you have a lot of work to do.
Sounds good.
All right, we'll see you back.
Thank you.
Good to go?
We are good to go.
This is Alicia Drake, 23M3136. Ms. Drake appears, Ms. Page appears on her behalf, Mr. McCall appears, and Ms. Doherty graciously, who's here for a different matter, graciously agreed to stay on behalf of probation. Actually, Ms. Drake stopped Ms. Doherty. So that probation can offer the input. Let's start with this, Ms. Page. Do you need further reading or advisement on the summons and complaint?
No, we do not.
Okay. Other than that, I'm wide open.
So Miss Drake has completed her 24 hours of useful public service. It looks like it got completed on 7/17/2026 is when she finalized completing all of it. And so, yeah. Oh, that's when they gave her the papers. Okay,
So we're done with useful public service, and was that it for probation?
that's my understanding, yes.
I'll go to,
I'll ask about it.
and Ms. Doherty, anything left to do? I understand it's not your case. I appreciate you stepping in.
Mr. Honor, can you just give me a moment? I've just got into.
I'm sorry, I'm having trouble hearing.
Do you mind giving me a quick moment to review her
Sure.
case? I reached out to Darlene, and I don't see a narrative that she received.
Yeah, I have a copy of the probation violation complaint if you want that.
No, I can pull it up here.
The allegation, it's a single count.
Okay.
And the count is a failure to perform useful public service.
If she's completed that and has turned that in, is that the completion?
Yeah,
BJSD.
I have it right here.
Oh, yeah, yeah.
Okay, so that's it. Okay, Mr. McCall?
Your Honor, I remember this case. I think I brokered the deal in it.
We'll take the next case next.
This was the outstanding issue. It's completed, so the people will withdraw whatever complaint they.
Are we ready to close probation?
This is the only outstanding thing, so I don't have an issue with withdrawing the complaint or just as having the case just dismissed outright.
Okay, and I note, yeah, so this case is hereby closed. Probation is terminated. Ms. Drake is off paper.
And then I just want to clarify, Ms. Drake was saying that she thinks she has another open probation.
She doesn't have another open probation case that I see. Maybe Ms. Doherty would have more information.
I don't see it either, but,
She has a traffic infraction case in early September, but,
and that's what we wanted to talk about next at the
okay.
court.
Ms. Doherty, what do you know on probation?
Well, I do show she's on for 24M 181. And that one.
24181?
Uh-huh. And 181.
Let's find it, 24.
I will figure it out, I promise.
24 T or M?
M.
181. It show up that way, so sometimes the other way.
It's my understanding that case is closed out and maybe probation didn't get the memo or something because, no, that's not meant to be. Because somebody didn't get you the memo and it could,
Well,
it's my fault, everyone's fault, you know? So-
what I can share with the court is the last narrative that Ms. Dexter had in, she's discussing treatment,
What is the date of that?
July 23rd of this year. So, so this is what she put specifically. Defendant is that,
I see.
let's see.
I understand what's going on here.
Yeah, she has roughly, hold on. She has roughly 50 hours remaining in treatment. She's starting track F.
Okay. Yeah, there's what happened, the most recent court action was back in May. The people withdrew the complaint. So Ms. Drake just stays on probation.
I see. Okay, then my next question is, it looks like Ms. Drake has completed some useful public service, a lot of additional useful public service in 23M3136, because it was supposed to go towards this case. And so when
So
we asked.
she did the 24 in the case we called today.
Yes, and there are additional hours.
This is baffling for any clerk.
So I'm sorry.
The court calls 24M181, 24, let's start with this. In 23M3136, that case is closed, probation is over. Case 2, 24M181, Ms. Drake remains on probation. The people withdrew their complaint back in May. No changes there, except what is Ms. Page asking for?
I see a bunch of additional, let me handle this, okay? I don't want you to say anything that could be wrong, okay? So she has a bunch of additional hours here that it looks like went towards the wrong case, and I'm trying to make sure that she gets credit in the correct case.
So what you're saying is she did the 24.
Yeah, she has additional hours, and
In addition, she has done more hours.
yes, and I'm trying to do the math on how many hours that was, because those hours should be credited towards the 181 case.
I certainly don't object that. Do you, Mr. McCall?
No, Your Honor.
Okay, so total up the number, subtract 24, and I'm okay applying that number.
Okay, thank you.
And Your Honor, the reason we withdrew the 181 case was based, the only violation was based on a Bloomfield case, and the Bloomfield case was dismissed.
Okay.
That's why it was found.
Okay, did you, when you did it, what's it about? Okay, that's it. I have, 41.95 is the amount of hours.
So you think it was 0.95, wow.
I know.
So you think it was 65.95?
Yes.
Okay.
That's what
I don't know what 0.95 means, so I would agree to apply 41 hours to whatever, that's fine, I trust.
Can we
Ms.
do
Page.
42?
I'll round up.
0.95.
Round up, 42. Zealous representation by Ms. Page. Any objection to me applying 42 hours of useful public service?
No, I saw the document.
In 24M181.
No.
The court hereby gives not 41.95, but 42 hours of towards whatever her obligation is in 24M181. Ms. Page, we still moving?
Yes, one more question. So we have the civil infraction that we would be willing,
That's it on September 2nd.
it's something that we would be willing to resolve today, because the fear is Ms. Drake has gotten her driver's license, and the fear is she's going to go in that alone, unrepresented, and lose her driver's license again by being convicted of a driving
If
under
you and Mr.
restraint.
McCall can agree to a deal, I'll be happy to do it. Let me tell you what it is. I have jurisdiction, you have jurisdiction. I guess, maybe you don't have jurisdiction.
I don't,
You might, I do, Mr. McCall doesn't.
Yeah.
It's confusing because it says the people of the state of Colorado.
Yeah,
I know you would know better than me. I just, that's.
See, I don't know, because I don't do it. That's, so Ms. Drake has this case in September in front of Magistrate Harden. Ms. Doherty, I guarantee you, you don't have probation authority over a traffic infraction case.
No.
So, so I appreciate you staying, but
Just catching up on the notes.
perfect.
Thank you.
The charge is driving under restraint as a TIA.
Which is not civil, which is why it's.
Right, who testifies is a police officer.
Right.
I've done them. I don't know, in real life, what happens in those cases is a police officer comes, there is no district attorney present, but I think a district attorney could be present. Because I think it's brought by the people of the state of Colorado. But I don't know the DA's jurisdiction over that.
I mean, what I could do is make representations to the court and see if the court is inclined to go in the direction that I'm asking, and the DAs can make no
Well, you
representations.
can, I'll call the case. But you gotta give me a second. Tell me when you're ready, Ms. Dollar. This is 26R982, 26R982. This case is set in front of Magistrate Harden on September 2nd. I have, as I said, I have no doubts at all that I, Judge Grattan, have jurisdiction over this matter. My question is whether the district attorneys have jurisdiction. I think the answer should be yes. Because what you're asking for, I presume, is some sort of no point offense, right?
I am asking for either a no point offense or for a dismissal because I fear that Miss Drake will go into this proceeding by herself and then be convicted because at the time the facts may have been such that she could be convicted. But she has her license and it will set her back another year after she's spent a lot of time and money getting this license. And so that is why I'm trying to get this resolved for her today. So I understand the court can't negotiate, but I could ask the court to dismiss.
Well, right, but I am Magistrate Harden.
Thank you for handling this morning.
I
appreciate you, Your Honor.
Oh, happy to do it.
You worked so hard to get this.
I have disability in my back pain.
Yeah.
What's that? 26R982.
I have about 50 hours left of those
Right.
classes to do, so.
Magistrate Harden is gone this week. This will not help. Okay. It's a good point, because I should have known that, because for 2 of these days I covered for Magistrate Harden. Cry on the ball. So I will not send that message. Let me see if I have an answer. District Attorney is without authority to act. Colorado Revised Statute 42-41708 expressly addresses the District Attorney's limited role in traffic infraction proceedings. This is the AI answer, so please double check. Under that statute, the District Attorney or the District Attorney's deputy may, in the District Attorney's discretion, enter traffic infraction cases for the purpose of attempting to a negotiated plea or stipulation to deferred prosecution or deferred judgment and sentence, but shall not be required to do so by any person, court, or law.
I'm sorry, I have to listen to
Critically, the district attorney, it cites the same statute. Critically, the district attorney shall not represent the state at hearings conducted by a magistrate or county judge acting as a magistrate on Class A or Class B. Instead, the magistrate or county court judge is permitted to call and question any witnesses, and I've done that. So, as I said, there's no doubt that I, Judge Grattan, have jurisdiction, even though it's Magistrate Hardin's case. Mr. McCall, based upon the AI answer, which I'm looking at, Mr. McCall could move to dismiss or could agree to a settlement, but is not required to. But I'm now actually looking at the actual statute.
What's the statute again?
42-4-1708. 42-4-1708.
And if the court can excuse me while I look on my phone because my laptop died.
Why don't I just print it out for you?
I feel rude looking on my phone.
You're okay.
Thank you.
I don't know the statute. I have, other than covering for Magistrate Hardin, I never do traffic infractions. Ms. Cry, when that comes off the printer, if you could give that to Ms. Page. I've printed it out for you, Ms. Page.
Oh, thank you so much. Bad time for the computer to die.
No, there's no good time.
Yeah, that's true.
I find AI to be helpful in my research, but dangerous.
Yeah, it makes up case law. It's so scary.
It's so scary.
And it, not to mention, destroys the world, which is scary.
No,
It's scary.
It's scary.
Yeah.
It's helpful. I mean,
Oh, yeah,
it gets me going, but
in a very limited way. It's getting too big.
it's getting too big.
Yeah, under subsection 3,
Subsection 3, is that where we're looking?
yeah, it says, in the middle of the paragraph, it says, the district attorney or district attorney's deputy may, at the district attorney's discretion, enter a traffic infraction case for the purpose of attempting to negotiate a plea or a stipulated deferred prosecution.
Mr. McCall, my experience with you is you're a kind man. I will give you your option of whether to enter this case. You don't have to, but you could.
Your Honor, in this case, I think I will. If I can, kind of.
Okay, why don't, I'm not going to grant a motion to dismiss Magistrate Hardin's case without sua sponte. I'm just,
Okay.
right? But I'm not opposed to a plea to a no point offense. I'm not opposed to a TIB of some type. I'm not opposed to the people moving to dismiss, right? I mean, that can be true. But I'm not going to take a case off of Magistrate Hardin's docket myself.
I understand.
So, do you want to walk out into the ante room and just figure out what you want to do? I'll talk to Ms. Drake about the weather.
Okay, sure.
It's hot, Ms. Drake.
Oh, hello.
Yeah, you should be done with me by 3. Oh, and Luke's in town, so I'm gonna go home. Yeah, well, he was just in a month ago. We hadn't seen him since, he hadn't been here since Christmas, but now he's been here twice in the last month. Yeah, it's great. Ms. Page covering a lot of ground today. Back on the record, 26R982. Whoever would like to speak to me, speak to me.
Your Honor, I'm pretty familiar with Ms. Drake's cases. I think they were mine before
I think that's right.
temporarily was in Division 2. The fact that Ms. Drake is here right now with a full license, well ahead on her useful public service, I would hate to have to spend all that time and effort to have her lose her license again. We like to have people insured, licensed, and registered of their vehicles. This puts Ms. Drake in that thing, so we don't have to have her on the revolving door of coming back. With deference of not making Magistrate Hard mad at making this venture, but I do this thinking in the best interest of justice to dismiss this case.
I take it, no objection.
I technically don't represent Ms. Drake on
I
this
get
case.
that. You don't object, Ms. Drake.
No, Your Honor, no objection.
This case is I hereby dismiss 26R 982. I hereby vacate the hearing on September 2nd, pending in Division 6. That case is closed. Ms. Drake, I want you to do everything for probation until you are done.
Yep. I only have 50 hours of treatment and a little bit of community service, and yeah.
Good luck. Right, make
I got
it
my
happen.
house and my car, and finally got my disability, and I have one of my daughters back at home. I just had my other one here, but she should be back home shortly. She's in Mexico. So
That's great.
Ms.
Sounds
Drake-
like you've turned a corner.
yeah,
It's awesome.
I'm crying.
Yeah,
crying.
No, it was a little
It was
rough when you
just
first.
sobriety there for a minute that had me up.
No, you were out of control.
Yeah.
But
Yeah.
you're,
Honestly, I was, but it was the light of God. So
but here you are. And now you don't even have that traffic infraction.
thank you so much. I
Have a good
appreciate
day.
you all.
Mr. McCall, that was very gracious. Thank you very much.
Thank you so much.
Seemed to be the right thing.
Thank you. Yeah.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. So what